Yes, I want to say, I think at the outset, that if anybody here thought that Jim Allison's warning of fairly certain constitutional failure unless the state takes action was an overstatement, I am very sure, based on 40 years of my experience in two states and a lot of knowledge and advising in some of the states that Andrea mentioned, that his warning was right on point and fairly certain to be accurate over the not too distant future. It's not quite right that Massachusetts and New York are similar states. With respect to the right to counsel, Massachusetts is about as different from Texas as you could be. It's a totally state-funded, totally state agency providing direct representation. New York, on the other hand, where I've been for the past 6.5 years, has a lot of similarities to Texas. It has a primarily county-funded system. The amount of state dollars are terrifyingly small, have been terrifyingly small. The counties are on the hook, running up against their property tax caps. Most persons charged with a crime are brought before local, typically non-lawyer judges. Now, when I say New York and the problems of New York, I'm speaking primarily outside of New York City. And I know that New York's reputation, as the farther you get away, the more it's driven by news out of New York City. But the reality is, in the 57 of New York's 62 counties that lie outside the city, that the system has been in a mess ever since the state legislature in 1965 said this is a county obligation and a county expense, this implementation of the Gideon right. And it has taken New York years and years. Let me just go through a little bit of that history. It was only in 2001, after 36 years of struggling with the county-based system, that the actual the key senator and assembly person and governor's council who supported the original 1965 bill came publicly forward and said we made a terrible mistake. Experience has proven our predictions wrong, that the counties could handle this. It's a state responsibility. They proposed legislation. The legislation went nowhere. Now, if that sounds familiar, that's New York's experience. 2006, the chief judge commissioned a major study, which had a devastating critique. It said that New York's system is broken, it's fragmented, it has failed, it does not meet minimum constitutional obligations. And again, there was no political response in the form of state legislation. 2007, civil rights lawyers filed a lawsuit against the state of New York, very similar to all the cases that Andrea has mentioned. That case is Harrell Haring. What you've got here is the ultimate settlement of the case in 2014, but let me fill in a little bit of the gaps in between 2007 when it was filed. When I came into New York, when I say I came into New York, I came into Albany. That's the state capital, and that's where our office is, and that's, of course, upstate. The legislature had created my office, and one of the first things I did was call Jim Bethke. I knew Jim from various conferences and communications, and we've always communicated well, and I knew he had been trying to jumpstart some reform in Texas since the early 2000s, and so I called him for some advice, and I got some very, very good advice. And what we've tried to do in New York, even before this lawsuit settlement I'm going to talk about in a minute, was 2014. But in our first 3 years, we did what Jim and his staff have been doing. We've tried to intelligently use very, very limited state funding to improve the quality of representation in counties throughout New York. And we did a lot with that. We got some caseloads reduced. We got some counsel provided at arraignment. The New York Court of Appeals in 2010 had said there must be counsel at every criminal arraignment. Nobody should be held in jail or have their case start out without a lawyer by their side. That was not happening, and it was not happening in 2011 when I arrived in New York. And it's still not happening everywhere today. We've made the kind of progress, I suppose, that Williamson County has made, in generally speaking. Some counties are doing it 100%, some are doing it still very low. That's what we did for a few years, incremental reform, if you will. But what we also did during those years is we worked very closely with every single county in the state of New York, and especially with the New York State Association of Counties, which has been our biggest, most powerful ally throughout our history. Along with the State Bar Association is another major entity that has been an invaluable political ally. So in 2014, the plaintiffs and the state came to a settlement agreement. The plaintiffs were afraid that they weren't going to be able to make their case, and the state was afraid of the consequences of a statewide, expensive statewide settlement. So what they did is they limited the settlement to the 5 counties from which members of the certified plaintiff class had their cases in. These weren't the 5 worst counties by any means in the state. They were just 5 counties randomly where people had happened to be arraigned and had their cases. And they were from all the way from Long Island up to far upstate New York. And the settlement essentially covered 4 major areas. 1, there must be counsel at arraignment, and the state will pay for that. 2, there must be caseload relief, and I'll come back to that in a moment, and the state will pay for that caseload relief. 3, there must be, what can a lawyer expect? It's one thing to reduce a lawyer's caseload. So there were 3 components to something called initiatives to improve the quality of representation, an unwieldy title. But what it means is this. First, the lawyer who is assigned to represent a defendant must have the qualifications and experience suitable for the kind of case, misdemeanor or felony or violation. Secondly, that lawyer must have supervision and training so that the lawyer's performance can be assessed. 3, that lawyer must have access to investigators, experts, the time to sit down with the client and explore the defenses in the case. And that all is encompassed under the 3rd reform, and that is guaranteed to be paid by the state. And then the 4th was that there was eligibility determinations. Who's eligible financially for counsel was a nightmare. Every court all over New York State had its own idiosyncratic beliefs about that. And so my office, which was given the responsibility to implement the entire settlement, we were given an 8-person unit. We were at that point, we had 11 people in our office. We were given a unit of 8 to implement these reforms in the 5 counties. So from the point of view of people who are interested in providing effective defense and really implementing the promise of the Gideon decision, this was a fantastic substantive settlement. And the weird thing about it was it applied to 5 counties out of the 57 that lie outside New York City, and it did not apply to New York City. And so we continued to work with the counties and the Bar Association, and we publicly stated, just as Jim Allison's credited Jim's office and Jim personally for speaking truth to power, for speaking truth to the legislature, that's what we did. We said, look, this is a great settlement. We're proud to be implementing it, but what about the other counties? What about the idea that there's a single standard of representation in the state of New York? What happened to that? And what's the argument against it? There is none other than how do you finance it, right? So what happened then was a political process in which resulted in 2016 in legislation, and this nobody in New York I've talked to has ever heard of this, unanimously passed the Assembly, which is Democratic controlled and tends to be kind of a downstate or city-centric body, and the Republican controlled Senate, which is a very upstate and more rural dominated body unanimously. Unanimously. Now, it went to the governor. It was a very expansive bill. The governor vetoed it on New Year's Eve 2016 on the grounds that it was too expensive. But in his veto message, he said, however, I agree that it's unfair to have only 5 counties benefit from the settlement that I entered into a couple of years ago. So I am going to propose statewide expansion. And that is exactly what he did. Going bridge too far there. Yeah, so this, I really want you to look at the second piece here, the statewide expansion of the Harrell-Haring settlement. We're still pinching ourselves. It's a 200 and ultimately, it does 2 things. It calls upon my office, this legislation that passed in April, calls upon my office, and we're running like crazy. We have a December 1st deadline to produce plans for implementing all of these settlement reforms in 62 counties, if you count the 5 boroughs of New York as 5 more counties, which they are, and 150 providers of representation. So we've got caseload standards to apply to each, and we have to cost everything out. But the estimate and the state's commitment is in the nature of, ultimately, it's a 5-year program. It'll be implemented over 5 years. By April 1st, 2023, the state has committed, now again, not appropriated, but committed to $250 million annually compared to the minuscule amount of state funding that's been there to date. So it's a gigantic accomplishment. I think the question you might want to know or think about is, how is this possibly relevant to Texas? We're not New York, we're Texas, we don't do this kind of stuff. Well, I think I go back to those unanimous votes in the legislature, both in 2016 when they passed the bill that the governor ultimately vetoed, and in 2017 when they unanimously supported these reforms that are very expensive. They've moved New York from almost the bottom of the barrel to very near the top of the barrel. I mean, it's not a state system. I know Massachusetts has a well-functioning state system. That's a beautiful thing if you can get it. But for a lot of states that are really county-dominated and county-centric, I think we're doing in New York probably about as well as you can do. The point I want to make here is every state can get out of the trap that Jim Allison and Andrea described of being in a slide into unconstitutional status, and then you're under a court order, and you're under years of litigation. Nobody wants that. I don't pretend to know what the answer is for Texas. I didn't know what the answer was going to be for New York. I thought when I got there, a statewide system was, boom, that's what you do, because that's what I had done. So every state is different. But the point is, you leave no one out of the reform process. Not because they're rural, not because they're conservative, not because they're left or right, because the Sixth Amendment right to counsel is everybody's right. And if you can't afford a lawyer, that shouldn't matter. It's still your right. And so the state, not each county, the state bears that responsibility. That's where the law is heading. That's where the law is going to end up. And the states that can get started with that process now and start building those coalitions, I understand you're going to have a really great guy up in Lubbock pretty soon who's going to be, pull in that part of the state. And, this can be done. It can be done in any state, I'm convinced. I've just finished a law review article that I can't distribute yet. It'll be in the Indiana Law Review in a month or two, and I'll be asking Jim to distribute it when it is. But this is something that is very feasible as long as you build together and don't leave anybody out. And I'd be, thrilled to hear your thoughts about whether this makes any sense at all from a Texas perspective. The other point I just wanted to make, there was also separately, the Office of Court Administration filed a bill to have centralized arraignments, because in New York, most arraignments take place in one of the 20 or 30 or 40 local village courts in each county. And so it's an authorization to do the arraignments in one central location in each county, which makes the provision of counsel much more feasible.
One
Caseload study, yeah, the caseload study, here it is. This is what we came up with for caseloads. There's two ways of looking at this. 37 hours for a violent felony, only 6.3 hours for a misdemeanor. That doesn't sound like a lot, but I'll tell you, the only national standards that are out there are much higher. There are 400 misdemeanors and 150 felonies without any breakout for violent and nonviolent, and they're expensive. About 200 million of that estimated 250 million in New York is devoted to caseload reform and reduction, and so. We did a big study that would have reduced those numbers even further. We engaged in a political process to see how much reform New York would be willing to buy right now. So we're happy with where we came out because these are definitely the lowest published and funded. They are already funded in the 5 lawsuit counties to the tune of $19 million a year additional, and they are promised to be funded in the rest of the state of New York over the next 5.5 years, as I say, to the tune of approximately $200 million additional dollars. So they very definitely will give real relief to the lawyers and who represent the clients and to the clients who are entitled to have a lawyer who has the time to prepare their case. Thank you.
And I'd like to make one clarifying comment, because I know from reading this case law, when you read case law from different states, this gets confusing. An arraignment in New York is the same as a magistration hearing in Texas. So when Bill is saying that they are now providing lawyers at arraignment statewide in centralized proceedings, he's talking about lawyers at magistration, not how we use that term, not how we use the term arraignment in Texas.
Okay. Thanks, Andrea. We call it counsel at first appearance in New York, but I didn't want to use that term here.
We have time for just a couple of questions.
Thank you. When does the appointment of attorney initiate if a person gets arrested on a warrant that has a bond attached, a bond amount attached, and is released before being magistrated, and later on appears at the arraignment, but he never was magistrated. He was released before that magistration period. Would there be an issue there?
I don't think the case law is entirely clear on that. Roth-Gary does not get to that directly. I don't know if you've litigated it in New York, but I don't think in Texas that scenario has been squarely litigated yet. I'm talking about basically it's let out by the piece off the sheriff lets him out, right? Without going before a magistrate.
Correct,
yeah.
correct.
So I would say in Texas, I don't know that there is clear case law on that.
There's not New York either. It's interesting, just 1 week ago today, the exact question came up at a county association meeting in New York. And if there's a hold on the person, essentially like a warrant for another county or another jurisdiction, then release to the warrant so that the case is mooted out. But the legal question, I don't think has been answered in either.
I also think it might depend on what type of warrant. So if it's a warrant issued after indictment is a separate trigger for attachment, and so then I think appointment of counsel will be requested. But if it's a pre-indictment case, I think the law is unclear. Well, the law could be clarified, but
Bill, just a quick question. How much is total state funding in New York, like when the lawsuit was brought or last year? Because you were talking about a system that was really woefully deficient in funding. So how much was between county and state? What was the total spending?
Right. Well, since when we began, total state funding was about 77 million, 8 localities spending 77 million. 40 million of that was funneled directly to New York City without any oversight by my agency. That 77 million now, 6 years later, is 81 million. So there's now about $41 million goes to the 57 upstate counties outside the monies that have been appropriated pursuant to the lawsuit settlement.
Very good. And how much are counties spending on an annual basis?
Counties are spending, including New York City, they've passed $400 million as of 2016. Well, I don't know exactly how much over. It's increasing at about 5% a year. About 200, it's taking 400 million as a round number. About 225 million of that is New York City, and 175 million outside of New York City.
Very good. And what is the population of New York?
New York is just flirting with 20 million.
Okay. And Wesley, how much is the state of Texas providing in funding total?
A little bit less, about 30 million, but total spending is about 236, I believe,
yeah.
last year.
All right. Very good.
236 million. So in New York, I'm hearing 400 county, another 70 state. So New York State is spending roughly twice as much as Texas, and is about a third smaller in terms of population. So it gives you some perspective on spending here, where we're at. So, well, thanks to our panelists for coming today, and they'll be around.